Namaste, good morning, and welcome. Hope you guys are doing good. Today we'll start with Companies Act 2013, the corporate law. This part has a weightage of 35 marks in your law paper. Okay, so this has a weightage of 35 marks. 35% of questions will come out of this part of your law portions. Okay, so this part is one of the important part in your law syllabus. Why? Because once you become a CMA, you will be doing incorporation of companies, then the filings with ROC with respect to increase in capital, SH7, PS3, then holding the board meetings of companies, then and also to conduct annual general meetings, annual filing with ROCs. So because you're going to work with the companies, we should know the Companies Act in detail. All the companies are governed by which act? The Companies Act. So because you will be working for the companies or in the companies, we must know the Companies Act in detail. Okay, so let's start with the Companies Act 2013. Okay, yes. So chapter number 1 deals with company basic concepts of companies, where we will discuss about what is a company, types of company, how to start a company, what are the formalities to be complied with for starting a company or incorporation of company. So all those things we will discuss in detail in this chapter. So let's start with the chapter number 1 of the Companies Act 2013. Okay, yes. Now before I get into this the chapter number 1 of Companies Act, let us understand few basic concepts of Companies Act 2013. Okay, yes. So the Companies Act, the name of the chapter is, the law is the Companies Act 2013 is the law name. What is the law name? The Companies Act 2013. Okay, so this act in total it has 470 sections. There are how many sections? 470 sections. Sir, are we going to study all these 470 sections at inter level? No. Few section numbers you study in the inter level and few section numbers you study in the CMA final level. Okay, so you will not be studying entire 470 sections at the CMA Inter level. Okay, next one, 470 sections. These 470 sections are grouped under chapters. In total we have 29 chapters. How many chapters? 29 chapters we have. So all the 470 sections are grouped under the separate chapters. In total we have how many chapters? 29 chapters. Along with this we also have 7 schedules. How many schedules? 7 schedules. So in the Companies Act we have how many sections? 470 sections, 29 chapters, 7 schedules. Now what are sections? As I discussed in the first class, sections are nothing but the numbers given to the provisions of the law are called as what? Sections. In total we have 470 sections in the Companies Act. These 470 sections are grouped under separate chapters or separate headings, and in total we have 29 chapters. For example, chapter number 1 of the Companies Act covers the section numbers which deals with preliminary and definition. Section number 1 and 2 comes under the chapter number 1. Then we have chapter number 2. Chapter number 2 of the Companies Act deals with incorporation of company and matters incidental thereto. Means all the section numbers which deals with incorporation of companies, they are grouped under section number, under chapter number 2, section number 3 to 22. So like this, based upon the topic with respect to which the section numbers are dealing, we group them into how many chapters? 29 chapters. And we also have 7 schedules. What are schedules, sir? Schedules are nothing but the area in which in detail information is given with respect to a particular matters. For example, Schedule 3 of the Companies Act. Schedule 3 provides the format of are the matters with respect to statement of profit and loss and also the statement of balance sheet. Okay, so chapter number schedule number 3 deals with what? The format of P&L account as well as the balance sheet. Okay, so like this, schedule 1 provides what? Schedule 1 provides the formats of MOA and AOA. So in order to provide in detail informations, we use the concept of schedule, and in total we have how many schedules? 7 schedules. Okay, sir, is this the only things which are under the Companies Act, sir? No, along with that we also have certain rules. What we have are rules. They are called as what? Called as the company's rules. The company's rules 2014. Most of the rules were enforced from which year? 2014. The company's rules 2014. Okay, so if you see the Companies Act, it is more of a administrative law, means more of delegated legislation. See what happened? A law or an act is made by the parliament. What is parliament, sir? When I say parliament, we have the bicameral system of parliament, that is Lok Sabha, Rajya Sabha, then the bill goes to president. Once the president gives the approval, it becomes a law or an act. So these sections, chapters, schedules are made by what? Made by the parliament. By passing a bill in the parliament, these are made. These rules are made by the executive. Who is executive? Nothing but government. So this law, Companies Act, delegates the power. What do you mean by delegates? Provides the powers to whom? To the government to make the rules. That is called as the Companies Rules 2014. See, for example, in the taxation, we have the GST Act. Along with that, we have a GST rules. GST rules are made by the GST Council, which is notified by the central government. Okay, and we have the Income Tax Act. Along with that, we have the income tax rules, which are made by the CBDT, Central Board of Direct Taxes, nothing but the part of the government. That is called as delegated legislations. So the parliament delegates certain powers to the government to make the rules or make the laws. That is called as delegated legislations. Sir, why, sir? Why these complications? Why can't parliament make all the provisions? Why? Because to make a law in the parliament, there is a set of procedures. You need to prepare a bill. That bill should go to Lok Sabha, pass in Lok Sabha, then it should go to Rajya Sabha, it should pass in Rajya Sabha, it should go to president should give an approval, then it should be notified in the official gazette. It is a long process. Let's take a scenario where there is a requirement of immediate change, means there is a requirement of extension of due date, or relaxation of payment of penalties or fees. And for doing that, if you want to pass a law in the parliament, it takes 6 months of time, 7 months of time, sometimes years of time. It won't serve the purpose, right? That is why to adopt the changing conditions, what happens? There will be what? Rules. The government can make the rules within the ambit of the sections or within the ambit of the act. Okay, so rules are easy to change. What is easy to change? Rules. If the government want to change sections, chapters or schedules, that requires a bill to be passed in the parliament. But to change the rule, just a notification in the official gazette is sufficient. So we have 470 sections, 29 chapters, 7 schedules. Along with that, we also have the rules. Rules are made by whom? Central government. So in central government, when I say central government, it is MCA. What is MCA? Ministry of Corporate Affairs. We have a separate minister to deal with the Companies Act matters called as the MCA. Okay, so in total, there are how many sections? 470 sections, 29 chapters, 7 schedules. Along with that, we also have the rules called as the Companies Rules 2014, which are made and notified by the government, MCA. Tell me, which one is easy to change? Is it the sections or is it the rules? Which one is easy to change? Can I get an answer, please? Very good. The rules are easy to change or easy to modify. The government can just make a notification in the official gazette and the rules are changed. You would have seen income tax rules, GST rules, companies rules will keep on changing because the government changed those rules based upon the requirement in the society. Okay, so that is why Companies Act is more of a rule based law now. For most of the laws, most of the rules we have is, we have 75% of rules and 25% is the act. The governance is like 75% are what? More of rules, 25% is what? Of sections and provisions. Okay, this is the structure of Companies Act 2013. So along with this, we have the mechanism, administrative mechanism, means who are the, or what is the department in the government which is going to manage this Companies Act or oversee the enforcement of Companies Act. We have a separate department in the government called as MCA. What is MCA? Ministry of Corporate Affairs. And who is the Minister of Corporate Affairs? It is Nirmala Sitharaman. Usually, whoever hold the portfolio of Finance Minister, they also hold the portfolio of Corporate Affairs Ministry also. Okay, so under MCA, what we have? We have the regional directors. For each regions, there are directors appointed. They are called as what? Regional directors. There are how many regional directors? 7 regional directors. Under regional directors, what we have? We have the ROCs, Register of Companies. Okay, so we have the Register of Companies, Registrar of Companies, ROC, where all the filings will happen. Okay, so at the top level, what we have? MCA. Under MCA, what we have? Regional directors. We have divided India into 7 regions: North region, South regions, Northeast regions. Like this, we have divided into 7 regions. Each region has one head called as the regional directors. Under regional directors, what we have? ROC. The ROC is nothing but Register of Companies. Every state has one ROC. How many ROC? One ROC, except the state of Maharashtra and Tamil Nadu. Okay, so every state has how many ROC? Remember this point is very important. Every state has how many ROC? One ROC. For example, ROC of Karnataka, we have the office of ROC of Karnataka in Bengaluru. Okay, so every state has one ROC, but there is an exception to this. What is the exception, sir? The exception to this is, there is an exception in state of Maharashtra and state of Tamil Nadu. In these 2 states, we have how many ROCs? 2 ROCs. What are 2 ROCs? In Maharashtra, we have one in Mumbai. One in where? Mumbai, and one in Pune. And in Tamil Nadu, where we have one in Chennai, and one in Coimbatore. Other than these 2 states, every state has how many ROCs? One ROCs. So we communicate, we have the interactions with whom? ROCs for filing of documents and also for incorporation of companies. ROC will report to whom? Regional directors. RD will report to whom? MCA. MCA will report to whom? To the government, that is the parliament. Okay, so this is with respect to a mechanism, overseeing mechanism, to oversee the enforcement of Companies Act. This is the mechanisms, a governance mechanism. Okay, so now after this, we also have some more departments in the government which deals with this company matters. That is, we have a department called as SFIO. What is SFIO? Serious Fraud Investigation Office or Officer. So if there is any frauds in the company, the investigation is done by whom? By the SFIO, Serious Fraud Investigation Office or officers. Along with that, we also have official liquidator. When liquidation of company happens, there will be a official what? A liquidator. Official liquidator. So we have the official liquidator's office in Bangalore. Okay, in MG Road, Rise Towers, 11th floor, we have the official liquidator's office. So if you want to close a company, you need to appoint an official liquidator. What he will do? He will list out the assets and he will discharge the liabilities. This you learn in accounts also. You will prepare a statement of official liquidator, right? Where you will pay his expenses. That you learn in liquidation of company, accounting for liquidation of companies in the accountancy. So we have the official liquidators. Along with these, we also have for a dispute resolution mechanism. Let's say a shareholder has a dispute with a company, or a board of directors have some disputes, or there is you need to go for amalgamations or merger of companies, or you need to go for, you want to file a case for, petition for insolvency or bankruptcy, or you want to revive a company strike off. So to deal with all these adjudication matters, decision means solving the disputes, we have a separate mechanism. Earlier what used to happen, the cases used to be filed in the civil courts itself, but civil courts are already burdened with so many cases and there was no expertise to deal with these company matters. So in the Companies Act in the year 2016, what government did, it established a tribunals. What is tribunals? Nothing but a special forum to address certain disputes. Example, in case of family matters, we have a separate tribunals. Okay, family court, we call it as what? Family court. You will not go to the civil court. In the same way, to deal with the matters of companies, we have a separate mechanism called as tribunals. We call them as what? Tribunals. So if you have a disputes, the first level of filing a suit is what? NCLT. NCLT. What is NCLT? National Company Law Tribunal. National Company Law Tribunal. So if you have any dispute where you can file a petition, National Company Law Tribunal or Tribunal. National Company Law Tribunal. So against the NCLT, you can go to an appeal to where? NCLAT. If you are not happy with the order of NCLT, correct, right? It is not final. NCLT orders are not final. Against NCLT, where you can go? You can go to the NCLAT. What is NCLAT? National Company Law Appellate Tribunal. National Company Law. Which tribunal? Appellate Tribunal or Tribunal. Appellate Tribunal. Against NCLT, where you can go? You can go to the Supreme Court. Supreme Court is the court of last appeal. That is the last court where you can go for an appeal. Okay. So if let's say you are a director of a company, you want to file a case against the company itself, or you are a member of a company and you are not receiving a dividend, or there is a mismanagement in the company, you want to file a case against directors or against company itself, where you can file a petition? You can file a petition in NCLT. If you are not happy with the order of NCLT, you can go to an appeal to where? NCLAT. Against NCLAT, where you can go? You can go to the Supreme Court. Supreme Court is the court of last appeal. This is how the disputes are resolved. Okay. So NCLT has benches. See, what is bench? Bench is nothing but where the hearing happens. For example, High Court. High Court means there will be only one High Court for each state. But there are few states where for 2 states we have one High Court. Okay. So in Karnataka, we have a High Court of Karnataka. The principal bench is in Bangalore. But we also have one more bench where hearing happens in case of Kalburgi, because the people cannot travel from Kalburgi to Bangalore for attending the cases, right? So there is one more bench where hearing happens. Okay. In the same way, NCLT means only one. For entire nation, we have one NCLT, but the benches were there in multiple states where hearing happens. In Karnataka, for NCLT Karnataka, we have that NCLT bench where in Bangalore, rise at ours 12th floor. Okay. So NCLT, against NCLT, where you will go? NCLT is in New Delhi, and against NCLT, where you will go? You will go to the Supreme Court. Supreme Court is the court of last appeal. Okay. So this is the basic concepts which you should know before you start studying what? The Companies Act 2013. I hope you guys are clear with the concepts of Companies Act 2013. Any questions, any doubts? Okay, so can we start with the topics now? Yes, let's start with the company.